Hi guys, my name's attorney Manny Serra of the Rossen Law Firm. I'm the managing partner of our firm. We're here to provide you a presentation on how to handle your first DUI in the state of Florida. We practice primarily in South Florida, so Broward, Dade, and Palm Beach County. But a lot of this obviously is going to be applicable throughout the state. So happy you're with us. Hope we can help you out. There's going to be 4 different sessions that we're going to go over with some colleagues of mine. Session 1 is the one I'm going to be doing, so obviously it's going to be the best one. The initial client interview, that's where you find a lot of gold and you kind of set the trajectory of your case. Session 2 is going to be how to issue spot and work case pretrial. So this is going to be those legal loopholes, those motions to suppress, motions to dismiss, and kind of issue spotting, things to look out for. Session 3 will be the basics of DUI science and field sobriety exercises. So if you're concerned about how do I breathe a breath case, is the breath test infallible? What are these standard field sobriety exercises really testing? How are they measured? We'll go over all of that with you. That's always probably the most fun of all of them. And then 4 is the DUI trial experience. So obviously, not a lot of cases actually go to trial, but many of the DUIs get set for trial, especially if you're in a county that kind of does that rocket docket or that very quick misdemeanor counter call status, case dispo, jump you right into a trial. So we'll teach you how to kind of prep up to that and make sure you're prepared, motions in limine, things of that nature, jury selection, all that. What we've experienced throughout our career that can give you some tidbits and help you kind of evolve your case and your practice. So the initial client interview, again, my name is Manny Serra, happy to help you out. At the end, there'll be a QR code. If y'all want to scan it, get in touch with me. I'll be happy to help you out. It's my pleasure. I really, really enjoy this stuff. And I'm very, very passionate about the initial client interview because I believe this is where you can make or break your entire case and your relationship with your client. There's also a lot of bar-related kind of ethics rules that you want to be on the lookout for. Obviously, as kosher as possible. We're going to that so you don't step on a landmine. I'm always trying to do things as possible, and we'll go over that as we can. So, topic succession, right? Topics this session, right? Susan will talk later about slurred speech, I'm sure, and right there an officer would say that was a sign of impairment. But as we're going through these, we want to go through information gathering first. In my opinion, it's the key to a great defense. That gathering is going to be from your client mostly, that initial information, and from what you can find on the court, clerk of court. Remember, these meetings, what this portion is, these meetings are that kind of initial consult with a client. We like to call them strategy sessions. If you're a public defender, this is a lot of times you're meeting clients at arraignment. I was a public defender many moons ago, so power to you guys out there. But understand that when you're making that first interaction with that client, it's going to be really tough to do all of these steps. So sometimes having a form email of everything I'm about to talk about, if you're a public defender, to be able to send out to your client to fill out and send back to you is probably the best thing to do. I used to have a piece of paper in my judge's courtroom where I would have them sign it and fill it out with some of this information. People thought I was crazy, but now we're running a highly successful, kind of practice with data collection, making sure that we really hear our clients out. And I think everyone should really have a good practice for data collection. So that's the first part. Then we'll be providing education. So I think it's teaching how to really teach your clients about what to expect. Teach them about DUI. When you are educated in life, you make great decisions, right? Or better decisions than if you're uneducated. You don't want to make random guesses and kind of go on a whim. Oh, how do I feel today, right? There's a lot of things you want to go over with your client. So we'll be talking about what we really should be educating them about, especially if they're a first-time offender. Setting expectations is the third one. In relationships, they say 2 things are the cause for a breakdown of a relationship. One is a lack of communication, and the second is when expectations don't meet reality. So we want to make sure we set realistic expectations with our client. We don't want to make any guarantees either. And then finally, I'll discuss the DMV because during your initial consult with the client, if the arrest happened within 10 days, if the consultation happens within 10 days of arrest, there are some options that your client's going to need to know about. That's probably the most kind of, has the most minutia on that slide. You can Google it, you can review it, you can email me about it if you didn't get a full understanding of the rule, because it can be a little bit complicated, but just understand that there is some built-in urgency for a defendant after they've been charged with a DUI or received a DUI ticket. Information gathering, what we talked about, okay? So this actually starts before you meet the client. So, right, a client calls, he wants to have a consultation at 3 p.m., the call was taken at night or in the morning, you set it up, so what do you do next? So in some form or fashion, right, I want to try to get my client an intake form or a client questionnaire, a PNC questionnaire. PNC is potential new client questionnaire to review and see if we can collect data that will help give us a framework of how we need to craft this customized strategy of defense for our client, or really kind of the pain points that we may be looking into when they do come and meet with us. So for instance, we want to know their contact information and emergency contact, because God forbid, right, they can't make it, and maybe there's a pretrial warrant that they don't know about. We want to be able to reach out to an emergency contact and go, hey, so-and-so, have you gotten in touch with them? We haven't heard from them. We want to have kind of a brief description of the facts, see what they are alleging had occurred. I want to know the previous criminal history. That will be very, very important for if you're in a county that does diversion programs for DUI, prior DUIs, because as the statute says, your first, second, third, fourth, and so on, DUI has statutory minimum conditions that will apply to specific PNCs. So you want to know which number DUI this is for them. Also, this can count as a strike. And if you are familiar with the strike rule, if you have 3 DWLSs or DUIs, things of that nature, those strikes on your driving privilege, you can have your license revoked. So you kind of want to know that too going into that meeting, so you can explain the urgency or importance of this, because this is not just a DUI. DUIs can be really, really complicated, really expensive, have the FR44 insurance be applied to a person, and really kind of mess up someone's way of life because their car could be taken away. We also want to know about the immigration status, right? We want to tell our clients we're not immigration lawyers. I think I have something else later on the slide about that, and I would have a group of immigration lawyers that you trust and know and are reliable to provide or refer your clients to if they have immigration issues, because you never know what you don't know, right? You don't know your blind spots, and the worst thing you want to do is just guess or say, oh, I heard from someone, or I was taught at the public defender that it's no big deal for a DUI, or someone told me it's, you're going to get deported. Let us stay in our lanes, right? And I'm sure Susan will talk about failure to maintain single lane later as a basis for a stop. So let's stay in our lanes with our clients. Let's focus on what we know, be experts at DUI, and let other lawyers handle the other parts of law. Don't try to be a hero. And we want to know, are they currently on pretrial release, right? What are their bond conditions? So if someone comes into you and goes, hey, I keep having to call this person. Do I have to call them? Don't say, I don't know, we'll find out later. Let's look ahead, because a lot of times the pretrial release conditions are online and you can see what the terms of release are, and you can help walk them through what is expected of them. So that information gathering. First things first, let the PNC know that your conversations are governed by attorney-client privilege since they are coming to you for legal advice. However, caveat, try to do a conflict check as soon as you possibly can. I know smaller firms just starting out, it isn't that big of a deal, but as your case counts continue, as your career grows, you're going to have established relationships with witnesses, with officers, with clients. All of these things, judges, there are certain things that you need to really start to be on the lookout for as that web of contacts and relationships grows, and have a plan in play or a tool in play or method in play to run conflict checks to ensure that you're not entering or engaging into a case that you're going to have to withdraw from and potentially have an ethical violation. However, you do want to let the clients know that it's governed by attorney-client privilege, because a lot of the times, and I like to use the analogy of, look, it's like talking to a doctor. If you have an awful shoulder and you tell the doctor, oh, my back hurts, but shoulder's fine, it's okay. And they go, when I do this, does that hurt? And you say, no. And really you're feeling that pain up your arm. You're not doing yourself any good. The doctor's going to misdiagnose you, and this is going to be, compounding pain and hurt to your body when it could have probably been prevented, right? They say that ounce of prevention is worth a pound of cure. So tell your client it's okay to be honest. It's okay. We're not here to judge. We're here to help, and make sure they understand that they can be honest with you. So the draw is not mine, but the slice is. So as anyone who knows or plays golf, I like to use golf as an analogy because I try to play it even though I'm very poor at it. Also, you can look at kind of a rocket ship. When a rocket ship takes off, that initial launch point, right? A little tweak left or a little tweak right, forward, back, can really, really, change where the landing. And it's that small little change. So if we get information that about, let's just say a client has a medical history of arthritis in his knee. If we don't get that at the data collection point, right, and we just go on that straight and narrow, that straight line, going that normal DUI, let's get the reports, let's get the dash camera, let's get the body camera, let's get as much as we can, let's look for some legal loopholes, let's look for constitutional violations, let's make some negotiations, et cetera, et cetera, et cetera, without fully knowing that the performance on the exercises, the field sobriety exercises that you're watching on a video later on or reading in the report, are the way they are because my client's normal faculties are not the same as your normal faculties or LeBron James's normal faculties. Why? Because he's got arthritis in his knee, and we could do some data collection and get some medical records and provide them to the state attorney, or even present them at a motion or trial if needed to explain some of the performance of field sobriety exercises. And that all starts in information gathering. That way, you can end up in the position that you want to at the end with a defense that the reason my client performed this way on field sobriety exercises was because of this medical condition. And that's just one of the very many ways that information gathering can change the way you defend your case, right? We can talk about accents, we can talk about concussions, we can talk about many, many, many things that may change that normal faculty standard in DUI to be more customized and complicit with your client's normal faculties. And you have to really paint that picture. I don't say certainly, but most times the officer doesn't do your client the favor of a full and complete thorough investigation into those injuries, although sometimes they ask. So, like I said, injuries and physical conditions are imperative to collect those, because if someone has, a problem with their eyes, that pen test, right, they're doing the horizontal gaze nystagmus or vertical gaze nystagmus test, they may perform a bit differently than someone else, and there's medical explanations to this. I'm not a doctor, and certainly the officer's not a doctor, but if my client does have a doctor, let's get those documents and medical history that we can provide that will leave an objective in the past, right? It's always better if they're in the past, injury or condition at the time of this incident that was not fully accounted for in the totality of the circumstances of Officer Smith arresting my client, Mr. Brown, and now all of a sudden we're in court and new things are coming out and the officer didn't know about these because he didn't do a complete and thorough investigation, or maybe my client was a little nervous to speak with the officer. What else? Speech impediments we talked about, language barriers. Down here in South Florida, there's tons of language barriers. My family's Hispanic. Not the same as a lot of the folks I spoke up with in Gainesville when I was in college, right? Everyone has different cultural, different accents, the way that they say a specific word, and speech impediments are something that officers fail to ask about all the time, and they're really, really common. People actually have some speech impediments that they may not even know of, but an officer certainly isn't going to be the one that diagnoses those on scene. What about a learning disability, right? It was told many times that you don't want teachers on a jury. To me, I love teachers on a jury because, especially for DUIs, because a teacher knows in school when they tell someone, hey, Johnny, make sure you don't throw paper into the green trash can, put it in the blue trash can. They know that, or they're teaching a lesson on, colonial America. On first go, students don't remember everything. Just because you told them once doesn't mean they're going to remember or do it correctly. And a lot of times the field sobriety exercise is when an officer's saying, I need you to stand on one right foot in front of your left, arms by your side, stay in the starting position until I tell you to begin, et cetera, et cetera, et cetera. And they're getting this slew of 15 different kind of things they need to do. Their head may get a little spinny, and even even the smartest people in the world and kind of most locked in people may need a second or third instruction to go, wait, what did you say again? And sometimes clients are too nervous to say that. So it's not just learning disabilities, but also learning curves. Make sure you kind of talk to your client about that. Ask where they're coming from and where they're going to. Why? What if we can find receipts or documentation or other witnesses that say, hey, I was with Mr. Serra 2 hours before at dinner. He only had one old fashioned, and that was all I saw. At least it shows that, and if we were painting a picture, what's the next thing on that timeline we can establish to really paint a picture of how many drinks did we consume? How much did we consume? How quickly did we consume? What did we consume? When did we last eat? Who saw you last? who knows your normal faculties better than a random officer, right? A stranger. So those are all things we want to do to see where they're coming from and going to. Again, that kind of falls right into the defense witnesses and exhibits. Those are important. Those are things that, especially during a plea, if you're never filling out a plea paperwork, they're always talking about, there's always language in there about defense witnesses. And we have a right to call witnesses on your behalf or cross-examine those called on the state attorney. We need to make sure if there's some witnesses, we at least collect their name and talk to them, right? It's your obligation. It's their life. You want to make sure we want to do what's best for them. It's a little more work for us, but that's okay, right? We want to overturn every stone to beat our cases or get a great result. And remember, there's much more that you're not going to get from the state attorney's discovery. So there's a lot of things your client may have, such as the medical documentation, receipts, defense witnesses, problems with their car. Maybe there's some security footage at some particular location. These are all things you want to make sure you look out for in your case. And this all happens before you even enter into a courtroom, right? This is from the initial consult, you're setting your case up for success. Also, what do we want to know? Their profession. Why is that important? Because different professions value the outcome of this case on different levels, right? What if your client is has a commercial driver's license, a CDL? This is a huge case for him, right? A massive case. What if he drives for Uber for a living? Right? These are all things. Needs to drive his kids to school and then to work, and then is a personal chauffeur. Drives or transports alcohol back and forth. There could be some conditions of no alcohol on some releases. So understand that we need to know the profession, because we need to know kind of how important this can be, not just the next 5, 6, 10 months, but 5, 6, 10 years, 20 years, right down the line. And it's important to let them know that we're not employment lawyers, right? We're not professional. And if you have a contact or kind of professional lawyers, but profession lawyers, and someone in that realm, if they need it, establish a good relationship with referral partners so that you can know and trust these people when referring clients there, because you're really going to want them to get good advice and not just kind of been sent to someone who's, not doing a good enough job or keeping your client's best interest in mind. Because there are, unfortunately, a lot of times with nurses and people that work in hospitals, they do those quarterly background checks, at least sometimes that we've seen, where it's going to pop up eventually. And you want your client to be prepared for that. And there may be a lot of questions involving their profession when you're speaking to them. Where they see themselves in 5, 10, 20 years, I know that there are certain HOAs or condominium associations that will not allow for someone with a DUI on their record to live in that community. They're very strict. We've had to write some letters to particular HOAs and condominium associations to ask for special permission for our client to live within the community. And an alternative, if they already live in the community, they may have to have a hearing in front of the HOA. I know that sounds awful, right? But just be on the lookout for some of that. Do they have any priors, right? Be on the lookout for that second DUI. If this is 5 years is the one you see most common. And that one has some very strict statutorily minimum mandatory sentences that go along with it. So make sure you know that, and your client may sometimes forget, I don't know if it's my first or a second, I don't know what happened to this one. Take your time, gather as much information as you can, and give him and honest with you. Her, the client's permission to speak true, to speak open. There is no judgment here, and you really, really need to know the outcome of those cases. And sometimes you're going to have to go into a county or a state that you're not familiar with on their clerk of court website and try to search through there and piece together as much as you can. But don't be afraid to be honest with them and go, look, I need to look into this a little bit more because I need to know what this really is for you. We don't know this right now. You can eventually get the criminal history from the state attorney or the offer from the state attorney. But at this time, it's kind of important that you take that extra step to try to help your client out as best you can. How open are they, right? What do they want to see happen? There are certain clients, and you guys I'm sure know about them, even if it's a young career, of, hey, I'm going to trial no matter what. I'm not taking a plea. Okay. Then you've got that I want a speedy trial type of client. You got to talk with them about the pros and cons of that. You have other clients who are so trial averse, and the last thing they will do is do anything that would risk an offer that has probation and no jail on it. And you want to be delicate with them and understand that this is a process, and make sure you don't do anything that's going to jeopardize an offer that is acceptable to your client. And now I know it's a little early to kind of gather that information, but most times when you meet with a client, they're going to have an idea of what's acceptable to them. And you can kind of work on that and establish those expectations as well. Would they be interested in that diversion program, right? Many diversion programs result in that reckless driving, or sometimes you can even get careless driving out of it. Understand, you want to explain to them the difference between being convicted of a DUI and getting a withhold of adjudication on a reckless driving. One can be conviction, you're going to have to spend for the FR44 insurance. So there's a lot that goes into this client meeting, and you want to show that knowledge so your client can really feel that you're looking out for their best interest and you know what you're talking about. Don't and bolster yourself, right? Let the client know that you're here to help and you know what you're doing. You're an authority on this, because clients need that in life. They don't need another lawyer down the street that's just going to please someone out. No, like let's be better than that. And you want to know if they're a citizen. I said that before, right? You want to check with immigration lawyers to see what the consequences could be, get their status. So providing education, again, I was just touching on that. You want the PNC. You want the potential new client to walk out of your consult with a feeling that you're an authority on DUI, you know case issues, and then you have an intimate knowledge of the court system. This starts before you step into the meeting or Zoom meeting with the PNC. How do you do that? Pull as much information from the clerk as you possibly can. So that is, what county is it in? What judge is it in front of? What state attorneys may be in that division? What do the pretrial release conditions look like? What are the judge's policies and procedures? Have you had cases in this courtroom before, with this prosecutor before, with these facts before, with the arresting officer in the past? If you are in a location that has DUI task force or DUI officers, you're going to see certain officers come across your desk over and over and over and over again. What if you can compare the reports and show how they are truly a copy and pasted report or one of those, auto-gen documents? And you can catch an officer and writing the same thing over and over again. Not to say that that's going to beat your case, but it shows that, look, we've dealt with him before. If you have some deposition transcripts, don't be afraid to share with your client how the officer is likely to testify. No guarantees. You're not providing no legal advice there. You're just saying, this is what we've experienced in the past with this officer. And don't forget to review the pretrial paperwork and bond paperwork. I said that earlier. It's really important that you don't tell a client he doesn't have to do X, Y, or Z when he really has to do X, Y, or Z, and then he gets a warrant for his arrest. That ain't good. So make sure you talk to them about that, walk them through it. From one of my favorite movies of all time, a little indie movie, 500 Days of Summer. On the left side, right, is the guy and the girl. They are together at dinner in Lowe's, and he's a tumultuous relationship that went through its highs and trying to get her back. And he goes to this party. He knows she's going to be there. Very romantic. And he's walking up the steps. And during the movie, they're showing both of these scenes at the same time. The expectations on the left, or on your screen now, and reality on the right. And as he's walking up, he's got like a bottle of wine or a present from her. He's imagining he's going to walk in. She's going to give him a big hug and a kiss. They're going to smile. They're going to have this intimate, kind of chemistry. He's going to walk her. That's what his expectations are, and it's kind of going through his head. But then in reality, what happens, right? The whole time they have that awkward friend hug, right? With friends with benefits type thing, not even just friends at this point, right? Where that awkward hug. She's talking with another guy. She introduces the other guy to the gentleman who's sitting with her at the table. I forget his name. He was in Batman, something Levitt. Sorry, I'm showing my ignorance of the whole thing, but the movie's fantastic, and I don't want your client ending up in that reality on the right when you're setting expectations the way on the left, where the expectations that this is going to be a great reunion and a great relationship, and we're back, and it's romantic and beautiful and amazing, and then you get that awkward, just friends hug. You're sitting alone, and you're getting introduced to some new guy she's talking to, or whatever it may be. It's a really, really good scene. I can't play it because of copyright issues, or else I would. So check it out if you want. If not, just think I'm, have a poor taste in cinema. So when we're setting those expectations and we're peeking behind the curtain, make sure you talk to. Sometimes clients think these are going to be done in 30 days. Sometimes they think these would be 3 years, right? We can continue this. No, right? Every jurisdiction is different, obviously. But you want to make sure that you establish the expectation of how long it generally takes. How long until we get discovery, right? After they file their information within 15 days. The state attorney is obligated to give us their discovery if we file our demand, and then we can file motions to compel. Let them know and what we're likely to get, how quickly it's there, and what value it is, and then set up when we're going to talk about it, right? Your lawyer is going to speak to you after we get the discovery. It's going to be sent over to you, and we're going to set up a call to discuss it and go over it and any questions you have, et cetera, et cetera. That's when we're going to talk again. We could talk about whenever that is, right after they sign up with you or after you meet them in court if you're a public defender. What happens next, right? Talk to them. Make sure you establish a plan. You don't ever want to go to a doctor. You see a doctor, and then they just kind of send you on your way. You always want that follow-up visit there because you should be doing something unless you're entirely cured. And we know our clients aren't normally entirely cured after one meeting, unfortunately. Let them know, right? When are we going to go to court? What is court like? If you have a waiver of appearance so the client doesn't have to go to court, you can go on his or her behalf. Amazing. Explain that to them. If your client needs to be there, tell them that. Keep it real. Don't tell them what they want to hear. Tell them what they need to hear. That's super important. And I don't want anyone, and I talk to a lot of young lawyers about this, giving a percentage of chances you can beat my case, right? That's a dangerous, slippery slope. That I don't recommend that. I really, really don't. I think it's really setting unreasonable expectations. Every case is so very different. You can tell them about previous cases you've had similar to theirs, but you also have to let them know that you need to do the work first, right? You're not even looking at the MRI or the X-ray of the case yet. You've just kind of looked at the body of the case. You haven't gotten depositions if you're in a certain county that allows for depositions on a misdemeanor. You haven't reviewed the reports. You haven't all of the reports. You haven't reviewed the narrative. You haven't looked at the body camera. You haven't looked at the dash camera. You haven't taken the DMV formal review yet if you opt to do that. You haven't pulled the CAD report or the 911 call if there is. You haven't spoken to independent witnesses. Understand, right, that there's a lot to do, and tell the client there's a lot to do. And we're willing to do it. It's just be patient with us, and here's our plan. Finally, let them know this is not a movie, okay? But it wasn't realistic, was it? Suits was a great show some years ago that I loved whatsoever, right? A Few Good Men is a fantastic, fantastic movie. If you've ever seen that, that's what clients expect to see in court. Theatrics, you dressed all the way in your Gucci suit, right? You there screaming at the prosecutor and, the judge, having some theatrical moment up there. When really a calendar call, you or a dispo or a status, you're walking in, you're speaking, it may take a grand total of 2 minutes and are perplexed by that idea and think you're a lazy lawyer or think you're not doing your job or you didn't even tell the judge what happened. So you want to manage those expectations and let them know how these court cases go, how hearings go, what they mean, what they want to testify at a motion or at trial. And most times they won't be speaking and they shouldn't be speaking, right? We want to protect them. So I can't stress enough that clients think that this is going to be, you may not think so, but they do. Trust me, we've talked to them. They think this is going to be some, big movie type of experience for them, when really, as we all know, it's kind of mundane and monotonous until it gets hot and wear that. The DMV rule. So as I said, so one of the things you want to collect from a client is their they will DUI ticket. So once they're arrested, then get bonded out, and when they are released from custody, they'll have in their property or from the jail the DUI ticket from the officer. Their license will be taken away, and they'll have a ticket in most cases. On that ticket, you can actually see some really important information. You can see the arresting officer. One of the other tickets may have the reason for the stop of the vehicle. If they're listed on there, we'll get into more of the breath samples later, very important. If it's a refusal, they may have a refusal on there. And then they'll have eligible for permit checked off or not. Sometimes officers don't know what they're doing or maybe make a clerical error and check it off if they are eligible, saying they're eligible for a permit and they're not, or saying they're not eligible for a permit and they actually are. A lot of the times you want to really look into that. That check doesn't really mean the world to me. It does provide some information, but we want to look into it a little bit further to see what's going on, truly going on. But that ticket they can then do two things during that time. One, they can say, I'd like to do a formal review or waive a formal review. And what is a formal review? Form review is a hearing with the DMV that is presided over typically not by a lawyer, judge, or magistrate, but an employee of the DMV most times. And that employee of the DMV will decide a fact. They're going to decide what comes in and what's not, what's relevant and what's not. Most times now they're done over the phone. Prior to COVID, you would actually kind of go into the office and argue them. So the officer can appear, and there'll be a little audio recording. I don't have it here, but we used to have one of the little, you click it, and it starts recording audio. And the hearing officer typically does that and records the conversation that you're having or cross-examination that you're having with the officer if you subpoena them to be there. That's like a free deposition, guys. Yeah, it's not free because there's some costs associated with it. With the DMV, does not allow, but at a particular time, right? If you're in a jurisdiction that offer depositions, this is an opportunity to question that officer and cross-examine them and get a record of it. So there are times where I think that it's actually best to do the DMV hearing for the purposes of the case itself, the criminal case. However, at that hearing, the hearing officer is going to decide whether there was a valid arrest, and then whether, a few other things, but mostly whether a valid breath sample was provided and it was over the legal limit, or whether a client refused the breath sample after being read their implied consent. You want to attack the breath machine itself, refusal after implied consent was read. So all of these things are what you challenge at the DMV. It's a preponderance of the evidence standard to win this hearing. You don't typically win them much. There's a lot of really good appellate issues that come from these. If you kind of look at our case law, you'll see a lot of it. But understand mostly in these hearings, information gathering is very valuable, where you're going to be able to question the officer. But during that hearing, if you were to lose, to elect to do, so that's the hearing, pardon me. And then within 7 business days after the hearing, they'll let you know whether you win or lose the hearing. So prior to doing that, you want to know, hey, client, Mr. Smith, I need to know, this is really subjective. It's up to you how you want to make this decision. I can advise one way or the other, the pros and cons. But again, it's your license, it's your life, it's your employment, it's your kids, it's your family, whatever it may be that they need the license to support. So here's what happens. Let me see. Do I go forward or back for this one? All right. So yeah, there's the 10-day rule that I spoke about. Those are some of the greatest dunkers of all time. We're missing Vince Carter on there. There's the statute. You have 10 days to do this. So here's the suspension. Here's kind of what happens. So if you do not want to do the formal review, you say, I need a hardship license ASAP. Then you have an option to waive the formal review if it's your first DUI arrest. And if you send in some paperwork to DMV to waive the formal review and you enroll in a DUI school, you will be eligible for that hardship license. And you don't have to have a quote unquote hard suspension of your license. Now your license is still going to be suspended if you refuse a breath sample for 12 months. And if you provided a breath sample on scene, even if it's double the legal limit, it will be suspended for 6 months. That's with the DMV. The court can resuspend your license, right? So it's not like you get gain time for the license that was suspended after arrest by the DMV, unfortunately. And you have to have that conversation with clients. But at that particular time, right, if you're waiving that formal review and you want your hardship license right away, it'll drive to school, work, religious purposes, what was the other, for like groceries, things of that nature. However, by waiving the formal review, you are admitting to that DUI being on your driving record, and you're going to have to do that DUI school if you want the hard. If you challenge the formal review, and let's do the first one, right? If you refuse the breath sample, you're facing that 12-month suspension. So you're trying to beat the 12-month suspension. You win that formal review, your license is not suspended by the DMV. However, if you lose that formal review, your license is then suspended for 90 days hard, meaning no driving. 3 months or so, no driving whatsoever. So for 90 days, there's no hardship, there's nothing. You got to Uber around, you got to have a family member drop you off, you got to take the bus, et cetera, et cetera. And so understand that there's a risk to this. Now you're kind of seeing, right, why some people elect to waive the formal review and get their hardship license right away. Others who are a little bit more risk tolerant or care more about the criminal case who want that testimony from the officer are willing to take that risk. If the officer doesn't show up, I forgot to mention this before I get on to the, if you did provide a breath sample, if the officer doesn't show up to the hearing, you can win, right? So long as he was properly subpoenaed to be there, you can win the formal review. And there are times where the officer just doesn't show up. It's fantastic, you win. So that is something to discuss with the client as well. It's happened more and more frequently, actually, to be quite frank, after COVID, but prior to COVID, the officers were usually showing up. I don't know kind of what correlates. Test, and you blew above the legal limit. Again, it doesn't matter if you blew a 0.16, 0.22, point whatever. If it's above the legal limit and you provide a breath sample, you are facing a 6 month driver's license suspension. And if you lose the formal review, that 6 month suspension is there, but you also have a 30-day hard suspension, no driving. Same as that 90-day above, but obviously a bit more lenient with 30 days. This is the one time where you get kind of rewarded for providing the same procedure as above, where you have to have a formal review, and if you lose the formal review, the suspension will then start after the formal review order is issued. So it's a bit complicated. It's very simply put if you read it the way I wrote it. I just decided to kind of expound on some things. If you have any further questions about it, I think we have some YouTube videos. You can Google it or email me. I'll be happy to speak with you about it. Understand that there are certain notices you have to provide to the state attorney. And there's a lot when you're these formal reviews as well. Like we can get into is if it's your second DUI, you're likely not going to review. You're going to have to do the formal review hearing depending on some things. Again, I don't have enough time, unfortunately, to get into all of that. But again, I hope this helped. Stay in touch. Okay, so I care tremendously about education, both clients, but also young lawyers or any lawyers around. I was provided a lot of education through my mentors, who I still keep in touch with, who actually just yesterday, there was a big issue on a case I was trying to figure out. I called a few people, and it was amazing to have people I trust, some not even in our jurisdiction. Don't be afraid to call or reach out. There's no judgment here. There are no dumb questions. I'm here to help, not hurt. Again, my name is Attorney Manny Serra. I hope you enjoy the remaining sessions of this. Always put your client's best interest first, and don't be afraid to tell them what they need to hear. Don't tell them just what they want to hear. Thank you.